Now, where do you approach, or who do you go to? Which are the courts that you approach for purposes of remedy? Like I said earlier, if you are aggrieved with regard to an infringement or any of these matters, the lowest court is a district court. If you are aggrieved because your patent has been revoked, or there is a revocation proceeding, or the patent is being granted to someone in which the patent is not there, or it is not a patentable subject matter, or it does not fulfill the requirement of patentability, you would approach the Intellectual Property Appellate Board, IPAB, which is based in Chennai. If there is, as in case of the previous one which I mentioned, I did not give you the cause title, that is Acme versus Interlux, the matter which was heard in Almora, District Court Almora, and then transferred to High Court. You can also approach the High Court or the Supreme Court by way of a writ petition or a special leave petition under the Constitution of India and exercise your rights there. And where, based on your pecuniary jurisdiction, you can easily go to the High Court of that particular place where there is a territorial jurisdiction. Like I mentioned before, the territorial jurisdiction in case of an infringement of patents is a civil court, and it would lie in the least is the district court, and then accordingly in the High Court based on the pecuniary jurisdiction. Post 2005 patent amendments, there have been a large number of patent litigation. Almost 75% of the patent litigation is in the pharma sector. The decisions that we have had from the court have been on as wide area as patent linkage with the drug regulatory system, the right of the pre-grant opponent to be heard in an appeal, and this was in the first business method case which was heard in the IPAB. The Section 8 compliance, where it said very clearly that because you have not complied with Section 8, which requires you to file the details of foreign applications and the corresponding foreign applications at the Indian Patent Office, and the patent was revoked, and the various injunctions. So, the remedies that are available under Section 108 of the Patents Act are injunction. So, you would have a temporary injunction and you can file for a temporary injunction, but you aim for a permanent injunction, which means that when you file a suit for infringement, you will also file an application for a temporary injunction. An injunction, as you know, is not a statutory right, it is an equitable remedy, it is a right in equity, and based on the various requirements that the court may look at, for instance, balance of rights, the prima facie case, the balance of convenience, irreparable injury that the plaintiff faces, the court may grant him a temporary injunction. A permanent injunction is what every plaintiff would aim for at the end of the trial. The court may also grant damages or accounts of profits. This is at the option of the plaintiff as a remedy. Another remedy that the court may order is a seizure and destruction of infringing goods. Another remedy that the court may look at, and it is very difficult in patent law because we are talking about patent infringement, and we are talking, as I said earlier, almost 75% of the cases are dealing with pharma cases. It is very difficult for the court to really come to a decision at a very early stage to decide whether there is actually an infringement or not. So, to sum up, the courts Under Section 108 of the Patents Act, order injunction in case of, I'm talking in case of infringement, any suit for infringement, may order injunction, and a temporary injunction is something which any plaintiff would seek at the first instance. A permanent injunction is something that he would look forward to at the end of the trial. Damages or accounts of profits at the option of the plaintiff. So the court may well order the defendant to keep the books of accounts so that the accounts for profits can be calculated, computed, and the same can be paid to the plaintiff if the plaintiff wins the case at the end of the entire trial. The court may also order seizure and destruction of infringing goods. Now, as I mentioned earlier, almost 75% of the cases of infringement deal with pharma matters. Almost all pharma matters are highly complicated in nature when it comes to understanding the technology therein. It is far more complicated than, for instance, patented technology relating to a mechanical instrument or electrical device or an electromechanical device. The chemistry involved in pharmaceuticals also requires a lot of data and evidence and tests to be conducted and submitted to the court. It is not easy to really have an early decision or an early remedy in such cases, and it may well be that the remedy that is received may not really justify the situation. In such a situation, many countries, I do not know of any instance where India has adopted this or Indian courts have adopted this, but many countries use one of the mechanisms available under arbitration, where by way of an appointment of a court commissioner who has an amicus curiae, who is well versed in the chemistry of the subject, arrives at an understanding of the subject matter, understands whether there is an actual infringement of the claims which have been granted patent, and submits this report to the court so that the court can then adjudicate on this based on the findings of the court commissioner who has been assisted by the amicus curiae. To conclude this particular module 39 and to summarize it, we often think of remedies under the patent law only insofar as patent infringement is concerned. We must remember that there are other remedies also for other problems that can be availed under the Patent Act. There has to be a deeper understanding of the issues, a deeper understanding of the solutions that can be availed under the Patent Act and also through negotiations and arbitration. Thank you.